from the College by the Lake, Coeur d'Alene, Idaho. Local, regional, national, and international guests discussing the issues and topics affecting the way you live are on Forum, the North Idaho College Public Forum, with your host and moderator, political scientist Tony Stewart.
Welcome to the fifth week in an 8-week series entitled Know the Law. Today we're going to pursue the subjects of wills, estates, and trust. And for you viewers who are new with us today and haven't seen the previous programs, we are doing this 8-week series in different areas of the law to try to be assistance to you about certain questions that can be very important in your lives. We're very fortunate to have as our guest today an attorney in the state of Idaho. Our guest is Robert Joseph Fosnot, who is practicing here in Coeur d'Alene, and his field of expertise is estate planning and probate. And so we're very fortunate to have someone that can so accurately address this question. Our guest was admitted to the bar in Idaho in 1986 after receiving his law degree from the University of Idaho in 1985. Prior to that time, in 1983, he received a BS degree in the field of chemistry. He also was a law clerk to, at that time, administrative judge for the 1st Judicial District, Gary Heyman. Robert, it's a pleasure to have you on our program. Thank you for taking time to assist our viewers with, again, one of our programs on the series Know the Law.
Thank you.
And as always, I'm very pleased to have Janelle Burke, our regular panelist, who is also an attorney in the state of Idaho, to assist me in questioning our guests, and I shall invite Janelle to commence the questioning at this time.
Well, Bob, welcome to the program. I know there are going to be a lot of people out there who are going to be listening, who are going to want to know some definitions of simple terms. What is a will exactly?
Generally, a will is a document that is written, that is one in which you make your desires known as to how you wish to pass your property or who you want to act as guardian, say, for your children.
So it's a way of passing your property. Now, is there such a thing as a holographic will as opposed to one that's typed, for example?
Yes, many states recognize what is known as a holographic will, which is a document that you yourself write out in your own handwriting. Idaho is one of those states. All of the terms need to be written out in your own handwriting.
But certainly a person would need to check in their own jurisdiction to make sure whether holographic wills are recognized or not before they exercise that particular means of writing a will. Is that correct?
That's very true, especially in this area of the law, because the statutes in every state are different and so specific that you do want to have some professional guidance before you embark on any estate planning decisions.
What would you say would be a major problem with holographic wills, for example?
Well, throughout the last 200 years, there's been a body of law that's been created that has certain requirements in it. And those requirements are not often known by lay people. So even though they may make a handwritten document, it may not still have some of the particular requirements necessary.
What is a probate?
Probate is generally a procedure that is employed once a person has passed away. You take the will that you want to admit into probate, file it with the court, and then a process is started whereby your assets are ultimately distributed to your heirs.
So it's a way of changing the ownership of the deceased's estate from the deceased into the heirs. Is that
it is.
Would that be a correct way to say that? Some people think that they're going to avoid probate by doing various kinds of things. Would you talk about that a little bit and what some of the dangers are in avoiding probate, or what some of the costs are?
Generally, and probably for good reason, the public has grown to fear probate. In the past, lawyers were able to charge a % of the estate value to do the probate, irregardless of the amount of work that was put into it. And many states have made rulings indicating that's not appropriate, and Idaho is one of those states. Typically, they can, and anybody can, avoid probate by doing a number of things, dependent upon the laws of your state.
And what are some of those things that they might use to circumvent probate?
Well, if you're in Idaho or other states that are community property states, you can enter into what we refer to as a community property agreement. It's a very short document that you sign with your spouse indicating all of your property is community property and that when you pass away it should be transferred to your spouse. That would be one way.
What about some other ways? Joint ownership.
You could have property jointly titled in such a fashion to avoid probate. Again, there are court decisions and statutes which are very specific on that, so you would want to consult a professional before you rely on the state of title, which is typically maybe on a real estate deed or a certificate for an automobile, things like that. Another way would be to enter into what has been commonly referred to as a living trust, and that would be a probate avoiding tool.
So I suppose that people would avoid probate for one of two reasons, basically. One, or perhaps there are three, but one might be that they would want to avoid the cost. Another might be that they would want to avoid the inconvenience, and a third might be that they would want to pass the property to a particular individual. Are those all reasons that people might try to avoid probate, and are they all reasons why people need to make sure what they're doing as they're trying to do that?
Mm-hmm. It is. Probably another real important reason is when you probate your estate, it's public record. It's something you file at the courthouse that anybody in the world virtually has a right to peruse through. And if you have a living trust, say, typically those documents and how you pass your property are confidential, and the public does not find out that information.
I have another, just two real quick questions. What's the difference between testate and intestate for our viewers?
Okay. When someone is said to have died testate, it means they've passed away with a will. And when someone dies intestate, it means they did not have a will.
And when they don't have a will, then what happens?
Then there's and every state has it, a complicated scheme as to how the property is to be distributed.
So it's distributed under the statutes, in other words. Mm-hmm. The law distributes it.
It is. If you don't consciously make that choice when you're alive, after you pass away, a court will step in and will distribute your property pursuant to, say, the default provisions in the code, which indicate property will pass this way if you do not have a will.
Let's pursue that some steps further, because what we're really getting into is a discussion with our viewers about what's the best way to set up whatever that you've worked hard for, and particularly when you know who you want it to pass on to within or outside your family. When you have a written will, is it correct that you can leave any portion of your estate that you wish to any immediate member of your family, a distant relative or a non-relative? Would you just explain to our viewers, how free are you in writing a will about everything that you own?
You are absolutely free and have absolute discretion to distribute your estate however you choose. If you want a portion of your estate to go to only a few of your children, you're certainly entitled to do that. There are some extra precautions in Idaho, as in other states, as to how you draft documents like that. But that
Can we pursue that just a little bit at this time? What would you need to do?
Sometimes people believe that if they just omit the name from the document, that's acceptable. The court will look at that and say, well, they've only named 3 of their 5 children, and so we'll give the property to 3 of the 5 children. But that's not true. A lot of states require you to specifically mention in the will that we are omitting this child. You do not need to specify why, but you do have to indicate their name and that you intentionally are omitting them from the will.
Is that why some individuals will put the name in the will and they will give them $1 or $100? Mm-hmm. Is that another way of trying to protect the bulk of your estate where you wish it to go?
That is a valid way to do it and is recognized in many states.
Going back to what Janelle asked concerning those individuals who opt not to have a will, and many people have chosen either not to have a will or just to not get around to it. Even Howard Hughes apparently had no will. They can't find it from what I've seen in newspaper accounts. And certainly he had a large estate. If an individual chooses not to have a will, but has relatives, what is the order in most states of law? Who's first in line to receive that estate? And I would assume if you had a spouse that would be the case, but from the spouse down, how would that work?
It can be very complicated depending on the states, but typically Idaho is a community property state, so property's characterized as either community or separate. And depending upon how it's characterized is depending upon how it passes. Typically, spouse will take all the community and a portion of the separate property, and then it depends on how many children and things to that effect.
But next in line to the, particularly I would understand, it can get very complicated in families, but if the spouse that is surviving is the only spouse that you've had, and then whatever children are from that, the spouse would be first in line, and then the daughters and the sons, basically.
Right, that is true.
Of the community property. If there are individuals that have not left a will, and let's suppose it's a second marriage, and to that marriage there are no children, and a lot of the property was acquired prior to that marriage, how does that affect the will? And there's children by the first marriage. How about the first spouse that the person is divorced from and the children? I would assume that would be quite different.
Quite different and quite complicated depending upon how that property has been treated, whether it has maintained the character of being separate or whether it has been commingled to become community property. You most certainly, by your heirs, a lawsuit that will be very expensive because you've not made your intent known. If you make your intent known, then people will generally respect that. They will see that in the document that you have specified how you wish to dispose of your property. But if you don't, and you have situations like that, which we do, you're going to wind up in an expensive lawsuit someday.
And the law could be so complex it would even be hard for the court, I would assume, in dealing with it. In relation to that, too, let us suppose that an individual has left a will and has been very specific and has omitted some individuals and had others in it. Then those individuals that have been omitted, but maybe their names are there, as you advised, to say that they choose not to leave. Then if there's a challenge to the will, it's much more likely, is it not, or let me ask in the form, is it more likely that the deceased wishes would prevail than if there had not been a will?
Yes, absolutely. Absolutely. Barring any factor surrounding the execution of the will, that is the time in which it is signed, that may show that perhaps it isn't the intent of the person that's passed away. For instance, undue influence or things to that effect.
There are many complications, particularly when estates are rather large in some. If an individual has been a very conscientious person through life and has had, changes in the not only in their wealth, but they've had changes in the status of their family. Again, that might be in a divorce and a marriage, or there might have been children by more than one marriage. All kind of things that can happen. And when a person chooses to have a second will or to amend their will, what advice would you give to our viewing audiences, particularly if they're two separate wills and later both the wills appear? How should one proceed to change a will?
I think in this area of the law, since you have estate taxes, which are very high, at a very high tax rate, you have potential challenges after you've passed away, you need, if you're contemplating changing your will, to consult a professional. Otherwise, invariably, there will be someone displeased after you've passed away, and they may have a right to challenge that will.
Is it wise, if you've had an attorney to write the first will, to keep with that same attorney as you do additional wills?
That's not necessary. Almost every subsequent will have a clause in it that revokes all prior wills. Okay. It's just important to pick a competent professional.
Okay. One other area I'd like to get into before we turn to Janelle, and that has to do with taxes, because we've been alluding to that issue. Again, on the street you hear conversations. It's kind of like in medicine and law. A lot of people on the street try to practice without a license or give it their opinions. I've often heard it said, without talking with a legal expert as yourself, that there is a difference in what happens to the heirs if there is or is not a will in relation to taxes. Is that correct? Could you explain?
There can be a very phenomenal difference. We all have a right to pass up to $600,000 of property free and clear of any estate tax. A properly drafted...
Excuse me, Madam, is that in all? Is that from federal?
That is a federal provision.
And so, 600,000 or below, there'll be no estate tax.
That is correct.
Okay.
The problem occurs is when husband and wife or married, they may have, say, $600,000 each. And if you do not have a properly drafted estate plan, when the first person dies, there will be no estate tax because there's another provision we'll talk about that takes care of that. But now the second person passes away and they have $1.2 million of value. They will pay approximately $235,000 in estate tax that would not be charged if they had gone to a professional to draft a tax planning will.
In relation to that, too, when you're talking about, most of our viewers, I'm sure, would be in the category under 600,000, and this is probably good news for them. But in addition to the federal estate tax question, how about state taxes on estates?
That can vary greatly by state. Idaho typically mimics the federal scheme.
And many states will do that, I would assume.
Right.
Okay.
The other exclusion that I referred to earlier is the unlimited marital deduction, which says a spouse can transfer to another spouse an unlimited amount of money and not have any estate tax.
And I assume with the community property that's spread across the United States that in the community property, both names are almost everything anyway, isn't it, prior to even the death of one spouse?
It really depends. I always require my clients to bring in all their documents that have title on it, and you would be surprised at what I see, because oftentimes they're talking to a neighbor who says, you really ought to do this or this, because of maybe a bad experience that they've had. Well, that neighbor means well, but that neighbor has effectively created a very bad situation from a tax perspective or a estate planning perspective.
So I think I hear you saying that sometimes it's better to have both names on certain documents and sometimes it's better to have only one?
Well, how you hold title to property is very complicated because there's joint tenants with right of survivorship, there's tenants in common. Idaho is a community property state. You look at the word that joins the two names together. I mean, it can be a very complicated scheme, and a lot of court decisions have been rendered on the area.
Janelle, I do want to ask one more question. We've been talking about avoiding the expenses of probate. If a husband and wife have a will and they're elderly and they both pass away and the children are inheriting the estate, because the will is there and it's so specific and it's under the 600,000 and so forth, do they need to go through probate in that case, or can they administer that some other way?
Well, in Idaho, as many states, upon the first death, oftentimes you do not need to probate.
Right.
There are summary proceedings which allow you to change title on property into the name of the surviving spouse.
Sure.
When the surviving spouse passes away, there does need to be a probate, because there is no mechanism to take the name of the surviving spouse who's passed away off of the title and put in the heirs, which is what probate does.
Okay, thank you.
Well, I have a couple of quick questions, and then I'd like to turn over to the area of trust. But the first question is, what about children who are born after a will is made, for example? A lot of young viewers may be out there who have a will, and now they wonder, they have another child. What should they do? What happens?
I think it's always important, anytime you have a change in your family status, to bring whatever estate plan you have to a competent professional to review. Typically, if you've had children, you have children that are mentioned in your will, and you have more children after that, they would be included in the distribution scheme on an equal basis.
So generally speaking, if you have a change, that's a good time to review your estate plan, your will and your estate plan.
It is. The difficult part about estate plans are when you pass away, there's no one there to express what your desires were, and if you have not written it down, it can be very troublesome.
Now, a little bit earlier we talked about changes in wills, and what are some of the things that you would say to our viewers not to do? Perhaps making their own marks on their wills, that sort of thing. What would you suggest that they not do?
Invariably, people change their mind through time, and some of that depends on how they're treated by some of their heirs and some not. Don't ever take your will and try and draw lines through provisions to write in other thoughts and ideas, because once you do that, you've basically destroyed the original intent of the document, and it will be challenged, subject to challenge.
So a good rule is to get with someone, do a second will, or do a codicil, whatever. Would that be correct?
You do need to bring that document to a lawyer that practices in the area, have them review it, and they may do a codicil, which is an amendment to your first will, or maybe just do a whole new will.
And where should people keep their wills?
There's a variety of ideas on that. Some lawyers will retain those wills in their office, the original wills, or in a bank safe deposit box. Other lawyers will give the wills to the client and have them retain it in perhaps a safe that they have at their home or at the bank, wherever they keep their other documents, titles to property and things like that.
Now I want to turn over to the area of trusts a little bit. What is a living trust? We hear a lot of talk about that.
A living trust is essentially an agreement that you enter into whereby you transfer all of your property to a trust that you've created. And you would invariably be the trustees of that trust. A trustee is one who manages that property.
So you're managing for yourself.
Right, and you would have the right to use that property essentially in any way that you see fit. And they are revocable agreements where you can change your mind and transfer the property back out of the trust.
Can you tell us a good thing about doing a living trust and then a bad thing about doing a living trust?
The good thing about a living trust is that you avoid probate. If you own real estate, say, in many states or in California, Washington, and Idaho, you would need to do ancillary probates in those states, and that can be expensive. So if you have a living trust, you avoid probate. There's continuity. When you and your spouse pass away, new trustees are mentioned in the document, and they have the power to carry out your desires, which invariably is to transfer the property to your heirs. That's the good thing. The bad thing is they're very expensive. Oftentimes they're as much or more than probate, simple probates. Another problem with them is they can be complicated animals. They require you to act as a true trustee, to take that property, to transfer it into the trust, and to maintain that. And what you don't transfer in, you may have to probate anyway after you've passed away to transfer it into the trust.
Now, some people think when I get sick, I'm going to transfer all my property to someone else, and that way I won't have to be responsible for it. I won't have to go through certain things. I won't have to pay taxes, etc. Is that possible anymore under the new laws?
What you're referring to would be trusts that were created in years gone by, Medicaid trusts. These are trusts where you have transferred property, now you no longer are the owner of it, and after a certain period of time you used to be entitled to receive benefits. Essentially in 1993 Congress greatly changed that law, and many practitioners avoid those. They're very complex and their effectiveness is highly questionable.
But there are charitable gifts that you can give. How does that operate? And maybe there are some viewers out there who have enough money that they would be interested in how can they help their favorite charity.
Well, the benefit about any gift, charitable or otherwise, is that you essentially are reducing the value of your estate, hopefully to bring it down within that $600,000 number. Now, if you give the property outright to a bona fide charity, you can have a tax deduction. Another mechanism is to do it by way of charitable remainder trust. You get a tax deduction, plus you get payments by that charity to you in the form of an annuity.
So as long as you're living?
Yes.
And then at your death it passes then to the charity? Is that the way it would operate?
Well, it really depends on how it's set up. It depends. Most of the time it passes to the charity. The charity has a right to use that property and you get the gift while you're alive.
Now, I know a lot of times today we've said consult a professional, but basically in the area of trust there are so many varieties. Isn't that true? There are so many different kinds of trusts, and how you want to use it depends on what you have.
There are tax planning trusts, there are living trusts, a variety. Charitable remainder trusts, grantor retained income trusts, or interest trusts, a variety of trusts.
But also for the benefit of our viewers, they shouldn't be afraid of those, right? There's something that a professional can explain to them and go through what are the advantages and disadvantages depending on what the person wants to do.
Like any professional, if you go to that person's office and they have not made it clear to you, you should probably seek another professional.
We're almost out of time. I want to get one other thing in before we get out of time. Sometimes there's a couple and one dies and the other spouse is elderly and has still all the property but does not have the ability to do transactions. They can also engage in something called a power of attorney to let another member of the family. Could you quickly explain to the viewers what the advantages of having that?
Mm-hmm. One advantage would be if you have executed a power of attorney, whoever you've given that power to has the same right you do to transfer, sell, buy, anything. Just they have exactly the same power you do unless you limit it in some fashion. So if you do have a stroke and you do not have the ability to sign documents, this other person can.
On that note, we have to end the program, and I just wish we had more time. I know Janelle joins me in saying to you that you have been most informative, and I know it's helped our viewers very much. Ladies and gentlemen, our guest has been Robert Foshnot, who has been discussing wills and estates and trust. I want to invite you to be with us again next week when we will do program number 6 in our 8-week series entitled Know the Law. And on that program, we're going to talk about personal injuries. I hope you'll be with us that time. And until then, please have a good week. I am Tony Stewart.
The North Idaho College Public Forum was videotaped live from the studios of Instructional Technology on the campus of North Idaho College for viewing at this more appropriate time. We invite you to join us again next week for another all-new edition of the North Idaho College Public Forum on this public television station.